Good afternoon and welcome to the Rule of Law podcast series. My name is Ola Ugwu and I'm head of our Public and Youth Engagement Program at the Bingham Centre for the Rule of Law. Today we will be focusing on the topic of judicial reform in Europe and having a comparative analysis of Ukraine and Albania justice system. I have with me today Dr. Gentile, Fellow in LSE Law School, specializing in constitutional law and fundamental rights with a focus in the digital environment. I also have with me today Dr. Julinda Beqiraj, Maurice Wohl Senior Fellow at the British Institute of International and Comparative Law, BIICL. And with us today as well is Professor Sergii, advocate in Ukraine and associate professor from the Institute of International Relations. Professor Sergii was also the chairman of the High Qualification Commission of Judges from 2014 to 2019 in the Ukrainian judiciary. Thank you for coming today and really looking forward to the session today.
Thank you very much, Ola, for the kind introductions, and good evening to all of you and this distinguished group of speakers. It's a pleasure to be with you today. So let's go straight into the discussion then. Today we're going to talk about judicial reforms in particular, and we're going to focus on two systems, Ukraine and Albania. In the last years, we have seen very interesting developments in both countries from the perspective of judicial reforms, and in particular, of course, in Ukraine, as we all know, because of the war initiated in Russia, also additional challenges have emerged for the functioning of the state and the public administration, and of course, courts. So with today's podcast, we're going to explore the dynamics of these reforms, and we're going to hear from our experts their national experiences. So let's kick off. I would like to start from Sergii and asking if you could describe the recent judicial reforms in Ukraine, and then we'll move to Julinda to cover Albania. Sergei, over to you.
I will tell a few words about the story, the total story, because for the last 33 years, when Ukraine got the independence, there were many reforms of the judiciary in different parts. But in 2010, when the President Yanukovych came, he initiated his judicial reform and took under the full and total control the judiciary, including with 3 high specialized courts and with zero authority of Supreme Court. And it was really the top of corruption, of state corruption in Ukraine. Then, as a result of it, we had the Revolution of Dignity in 2013, and then 2013, beginning 2014. And during the revolution, President Yanukovych ran out from Ukraine to Russia. He was a Russian, dependent Russian person. And after election of new president, new parliament, and creation of the new government, the President Poroshenko, who has been elected that year, he initiated the new reform, justice sector reform. It was adopted justice sector reform strategy, and during this, the main point of this reform was to eliminate political influence on election of judges and disciplinary responsibility of judges, and to clean up the corruption in judiciary. And then we spent 5 years during the reform. Maybe today we'll tell a little bit more about it.
Thank you very much. That's a very comprehensive overview, and it's very interesting to see that reforms affecting the judiciary have also occurred in Albania. And then perhaps I would like to contextualize these two reforms in the broader global landscape and also looking perhaps comparatively at other jurisdictions. But before doing so, I would like to hear from Julinda about Albania. What has happened in Albania?
So a similar judicial reform was introduced in Albania on basically the same grounds. So one was introducing an effective system of checks and balances between the different powers, so judiciary, parliament, and government. And the other reason was the introduction of anti-corruption measures. So, but all the process in Albania was driven by the possibility of European Union membership. So, in fact, the judicial reform process that was initiated in 2014 coincided with the European Commission progress report on Albania, that where it was noted that Albania should focus its efforts on key aspects of crucial importance, such as judicial reform, fight against organized crime and corruption, strengthening of protection of fundamental rights. And therefore, the objective of the reform was to address the shared perception that Albania was lacking an independent, accountable, and efficient justice system. And therefore, the vision of the reform was to restore confidence of the citizens in the justice system through an in-depth change, constitutional, legal, and institutional. So, in the words of the Venice Commission, comprehensive reform is necessary and it's urgently needed. And given the critical situation, critical solutions in this field are justified.
Thank you for this, Julinda. So it's very interesting to see how these reforms occurred as a result either of internal politics, internal dynamics, or as a result of external influences. And I can see here a combination of the two. So it's very interesting to see that the trigger of the reform has come from different sources. But now, just focusing a bit more on the reform before moving on to other issues. What was the procedure to appoint new judges? And was this procedure, in your view, compliant with rule of law standards? And if not, why? Or why yes? So perhaps I'll start again with Sergei.
Before we started our reform for practically all appointments in judiciary of Ukraine has been made by not secretly but in quite confident manner. During meetings in cabinets, it was necessary to visit several cabinets, then to propose something or future to services or money immediately or something like that, and we decided to make everything as transparent as it is possible, and even more than in Europe. For example, we made the competition to the new Supreme Court. It was a law which cancelled the old previous Supreme Court and the previous high specialized courts and created a new Supreme Court. So we needed to provide the competition there, and it was announcement that it will be competition. No any announcements before. You can imagine.
Okay, that's a big change.
Yes, a big change. We published all lists of all participants. We published all dossier of candidates, and every dossier was approximately between 200 and 250 pages.
Okay.
By the way, for this moment, we published all dossier of all judges on the website. Maybe we are a unique country in the world.
Okay.
And total. I called to the secretariat and they told me that for this moment there are more than 2,200,000 pages published on the website of the Commission about judges. You can imagine everything about their professional activity, about their decisions, about their relatives, about even some materials from the National Anti-Corruption Bureau, and as well as opinions of Public Council of Integrity. It is also a new feature. The participation of civil society in all HR procedures in judiciary. And in accordance to the law, a special law, there is a Public Council of Integrity with 20 representatives of different NGOs struggling with corruption. And they proposed us a lot of information about judges. We provided exam, multiple choice test, and then we studied for the judges, candidates for the judges. Then we provided, I think we are champions in the world when provided psychological testing. For tests. I also passed the test.
Well done.
That's
I never was
a judge.
no doubt.
Yes, okay. I never was a judge, but I passed. And just to feel myself how it is. And then we had, and it was also the first time in the history of Ukraine, we had files from National Anti-Corruption Bureau. It was my initiative that I go to the new agency, National Anti-Corruption Bureau, which created just before several months from this procedure. And the director of National Anti-Corruption Bureau invited me to his cabinet and showed me, as an example, one file about the judge. You can imagine the judge had, at that time, it was in 2016, he had 6 very expensive new brand cars as a property. His wife had officially 8 new brand, very expensive cars, and his mother-in-law owned 12. And I was shocked. I was really shocked, and I started to speak about this case during my interviews with no name of the judge. And the judge, when he heard about it, he certainly understood what it will be in the nearest future, and then he resigned and left the country. So they were we invited journalists and representatives of Public Council of Integrity for all our procedures. And on the second stage, when we had interviews with candidates, by the way, we made a stream with all interviews to YouTube. You can see it now, today, everything has happened there. And representatives of NGOs asked, had the right to ask judges with questions. And judges answered and explained why he or she bought so big apartments or several apartments, or why his mother, or it was one judge who had his mother had seven apartments on trains.
So if I correctly understand, journalists were involved in the process and were asking questions to judges for the public to know about their properties and how they managed to get these properties.
Properties, banking account, trips abroad, and not only about judges, but also about their close relatives.
That's an interesting event, in the sense that it sounds like the entire process, and in particular the anti-corruption unit that you established, really sought to involve the public in the, so to say, in fighting corruption in the judiciary, for the public to know as well about judges. And I think it's fascinating and also a very interesting example to keep in mind. And what about Albania instead? What about the appointment of judges and compliance with the rule of law? What can you tell us, Julinda?
So I will just make a link with something I said earlier, that the reform was a constitutional reform reflected in the laws and then in the establishment of new institutions. All of these were aimed at ensuring that the appointment of judges, their career development, the way they are promoted or disciplined, so whenever there are disciplinary sanctions, are made in compliance with the rule of law or rule of law principles. So first of all, in terms of, let's say, constitutional changes, 1/3 of the constitution was changed to reflect these new, the aims that the reform had, but also to ensure that the principles that are part of the rule of law understanding at the European Union level, Council of Europe,
so also the European Convention,
the European Convention, but also the work of the Venice Commission. All that is reflected in the law, constitutional law. Then, on the basis of the new constitution and the changes that were introduced in the constitution, a whole package of laws was also approved, which consisted basically in the establishment of new institutions. First of all, for the first time, the establishment of independent self-governance institutions for the judiciary and for the prosecution. Formerly, the body that would decide whether a judge was being promoted or not, or who would decide on disciplinary sanctions on judges, was a body that was that had a lot of political representation inside. So, since one of the purposes of the reform was to reduce political influence in the appointment and the career of judges, this was a necessary development, establishing a body that is self-governing the judiciary. However, also in line with the principles developed at the EU level and Council of Europe, as I said, etc., these bodies should not be, in order to avoid corporativism, should not be 100% composed of judges, so they are half and half, more or less. It's 6 judges and 5 from civil society. So there are 2 lawyers,
so
2 civil society, and 1 academia coming from academia. The same for the prosecution. There is still the High Judicial Council and the High Prosecutorial Council. Another important institution that was introduced was this ad hoc body, independent body, that pre-selects the judges of the Constitutional Court. Because the judges of the Constitutional Court under the Constitution have to be elected 1/3 by the Parliament, 1/3 by the President, and 1/3 by the High Court. This body avoids any political interferences by pre-selecting the judges and sends to these political bodies, or at least apart from the High Court, the others are the Parliament and the President, sends already made list. These are the best. Then you choose. You have some.
So there's a
amount of
exactly.
So a pool of 3 candidates. So they say these are the 3 candidates. You can, but that pre-selection is made by an independent body consisting of judges, prosecutors, and prosecutors basically from different levels. Another element of the reform, in order to ensure compliance with the rule of law principles, was something that you also mentioned, basically the 2 sets of checks for judges. The judges that are already in the system will undergo the so-called transitional reevaluation process, or vetting process, basically. So they undergo a triple check, finances, so financial check, connection with organized crime and corruption, and a proficiency check. So basically, whether you are up to be a judge or not. And it's interesting. So this is one side of it for the judges that are already in the system. For the judges that are entering the system, which happens through so after a 3-year training at the School of Magistrates, and then after that you have an exam, and then you become a judge, you still undergo a similar test, so proficiency not because you are entering the system, but resources, so financial test, and checking whether you have connections with organized crime or both
criminal
at the beginning,
checks,
criminal checks, yes, but it goes more than that. It's you might not have been convicted of any crime, but still you are friends with
so it goes even further.
I see. Further, and both for you, as you Sergei were mentioning, and for the closely related persons. So there is this check both when you start the School of Magistrates, the training, but also at the end,
later stage,
so that it's sure that you do not enter the system if you have any of those signs, either corruption because you cannot justify your assets, or connections with organized crime at the beginning when you enter. So let me just mention some statistics about the results of the vetting system, which is
the
procedure that the existing judges underwent. So there were about 800 magistrates, so about 400 judges and 400 public prosecutors and other high officials. It started in February 2018, and between then and now, the body that was specifically established for this, it's called the Independent Qualification Commission, so it's ad hoc. It will finish its mandate and then it's done, and then the rest of the checks will be done by the council. That I mentioned.
I see.
So in this period of time, they have more or less vetted 75% of the magistrates, so judges, more or less the same amount in judges and prosecutors. But it's interesting to notice that only 43% were confirmed in office, which means that a lot of judges either left the system because they didn't pass this test, or they resigned before going through the procedure because they were maybe sure that they wouldn't pass the test, which raises an issue about what are the resources that are necessary for.
Of course, there's a lack of judges.
There's a lack
of judges as a result.
There is an increase in terms of backlog.
Of course,
cases.
I see.
And as a result of that, there has been also a judicial map reform, and the new judicial map has been introduced, which has reduced the number of courts in Albania. And therefore,
there's an issue.
It is an issue, but maybe this is something that we can touch upon later.
Yes, absolutely.
What could be the solutions?
Very interesting. So I mean, just by hearing what Sergei and you have just mentioned, Julinda, it seems to me that the focus was really on anti-corruption, but also professional skills and qualifications, and therefore also aptitude towards the judicial profession. So these are, in my view, listening to your overviews, the pillars of these reforms. And by reflection, of course, this goes back to the rule of law, and also ensuring certain standards of transparency, fairness, and also independence, right, of the judges in relation to politicians, but also third parties that may have some dubious credentials, and then therefore could potentially, so to say, influence unduly the activity of judges. So I would like to pick up on judicial independence in particular, and not think now about how judges came to be appointed, But looking rather at the outcome of these reforms in terms of judgments, how these reforms have impacted, if you have any views, the protection of individual rights. Do you find that these reforms have enhanced the protection of individuals' rights by way of enhancement of access to courts? What do you think has been the impact for applicants, for people defending their rights? Sergei.
Thank you. I would like to give you some more examples from statistics also. When we came our positions, and when I became a chairman, by the way, when I became a member of the commission, there were only judges at that time, and they all voted for me as a chairman. It was really a shock for court system. It was a scandal, and judges did not understand why not judge. I was at that time academician and advocate, and why you voted for me? I became a chairman. Yeah. And when at the beginning we started so-called the primary qualification assessment of acting judges, as we told, there were approximately 8,000 judges in the system. There were more, but approximately 400 judges stayed in occupied semi-island Crimea, and they became judges of Russia. It was such effect, but approximately 8,000. We began the primary qualification assessment. There were 381 acting judges.
Oh, okay.
Assessed for 4 months, and only 69% from this quantity confirmed the possibility of carrying out justice into the relevant court.
Oh, wow. Okay. So around 30%.
Yeah. But what has happened after it? After these 4 months, first 4 months, during the next 4 months, 1,500 judges and 500, sorry, 1,500 judges resigned by their own decisions.
Oh,
why? Because one of the main reasons was that they understood that the interview with them where we asked them about their property and property of their relatives, and such a kind of information. Now it will become transparent for everybody in this country, and they left the profession in the judiciary. And then, if to speak about the commission, the composition of commission of the new commission, high qualification commission of judges, was 50-50 in accordance to European standards. 50% judges or resigned judges, but in our commission we were 16. There was 10 judges or resigned judges.
Okay.
Other people were advocates or academicians.
Okay. Okay.
I was advocate and academician.
Okay. We too have.
If to speak about the high constitutional body, the High Council of Judiciary, the same. 50% judges or resigned judges and other representatives of other law professions.
Okay.
Advocates and academicians, or mixed.
Okay.
And
how did this?
we canceled the influence of parliament in the procedure of appointing of judges. We canceled influence of any other bodies from all HR procedures in judiciary. What was interesting more during this primary qualification assessment, it was a very simple exam to write a case study, to write a draft of the court decision, but it was only one serious demand from the commission. we told to judges in the instruction, use the decision of the European Court of Human Rights.
Okay.
And then all judges in the country immediately started to use it much more often than before.
Okay.
And if you will see on the statistic, it rises up like this. And now we can see but it seems to me that more than 50% or 60 or 70% of court decisions, the practice using the practice of European Court of Human Rights.
Very interesting. So basically, the influence of the Strasbourg Court has been quite strong in shaping judicial independence. But it's also interesting what you just mentioned, Sergei, that many judges had to resign. And had this created any challenges for applicants who were seeking to access courts? How this transformation impacted individual rights?
Simultaneously, we permitted not judges to become judges.
Very interesting.
In the Supreme Court, by the way.
Supreme Court. Oh,
Supreme
wow.
Court
Okay.
and appeal courts and high specialized courts.
Okay.
When we started or planned to make first open competition to the Supreme Court, we started made the research of practice how in other more than 40 countries this procedure is engaged, including United States, Canada, Great Britain. It was a new Supreme Court from 2010. In Italy, it was a big Supreme Court. In the United Kingdom, quite small. In the United States, 9 judges.
Yes.
Canada, 9 judges. But in Turkey, big Supreme Court. And we saw we saw, for example, in the practice of Portugal, it's a small country but big Supreme Court, 65 judges. They have a quota for non-judges of 15%. It seems to me, or 10 or 15%. We did not have a quota, but in the new Supreme Court we had 23% non-judges.
Okay, but so there were other criteria, I guess. So
3 criteria: professionalism, professional ethics, and integrity.
Okay, I see. Okay, very fascinating. Yes, in fact, I mean, you're very right in pointing out that there are so many Supreme Courts around the world where there are untrained judges sitting as judges, but there are of course other.
But there are only 2 countries which make a stream from interviews. Ukraine for all candidates.
So all candidates were interviewed
and streamed
on
with unpleasant questions.
On which platform? Was it
YouTube.
on YouTube? Oh, wow. Okay.
You can see it. We can see it now immediately if necessary. And there is another country, another country, United States. When the president proposed to the Senate his one candidate of one position, we streamed all candidates. Yes, we had in the first competition we had almost 10, even more than 10 candidates for one position.
Oh wow! Okay.
One vacancy.
Okay, that's a big competition, but also I think that yes, this practice of streaming the appointment procedure is fascinating, in particular for the public. Yes, sorry, I wanted to add something.
And one procedure as election of judges to the new High Anti-Corruption Court. We invited international experts. Also.
Okay.
There were 6 of them and 16 members of the High Qualification Commission of Judges. They were, by the way, 2 from 6 from Great Britain.
Okay.
The resigned judge and the resigned prosecutor. And from Canada, North Macedonia, Lithuania, and Denmark.
Okay.
6 of them, and they have a crucial role because if not even all of them vote against this candidate, cannot
be appointed.
And
very interesting.
It's one more possibility to avoid a political influence.
Of course, absolutely. It's a very good point that the one that you're making now, that the participation of international bodies or simply international representatives in these procedures can, of course, ensure further respect of judicial independence because of the absence of a link, we can say, between that international representative and the country. So that's fascinating.
By the way, if it's possible, one last example.
Please, yes, and then we move to Albania.
Our new Supreme Court has per year at least 70,000 cases. It's a big
70,000 cases. That's very impressive.
For this moment, there are approximately 180 judges.
Okay,
But 70
180.
more than, yes, and 80, yes, something like that. And approximately 70,000 cases. During the
that's
last
impressive.
year, it was 40% minus, but generally
It's impressive. And
70
and
even more.
Ukrainian courts
Totally,
are working now.
total system a little bit less than 4 million
Oh,
per
wow.
year.
Okay.
And last year minus 35 or 40%.
Wow. It's and of course, I mean, it's impressive that Ukrainian courts are working, notwithstanding the war. I mean, it's really testament to the strength of the country in this very sad and horrible war. Julinda, what about Albania? So, what about judicial independence, protection of judicial independence? And you already very nicely illustrated some of the reforms and how they shape judicial independence. But again, it would be very interesting to hear from you as well about Albania and how these reforms have impacted the ability of individuals to access courts and to get effective protection of their rights.
So, as it usually, so let me first touch upon one of the points that, and then I will respond to this. It's just about the participation of internationals in the role of the international community in reform. As I mentioned at the beginning, the reform was partly, to a great extent, driven by the possibility of EU membership. So that already provided the target. But in the context of the involvement of internationals, formal involvement of internationals, it is foreseen in the Constitution that an international body will be involved in the vetting system of judges. Otherwise, in the election or selection of the membership of other bodies, such as there is also an anti-corruption court and an anti-corruption investigative body, as well as prosecution. It's called SPAC, special court on anti-corruption. So that is wholly left to the independent governance bodies that were established. So national, the only place where internationals are involved is in this vetting process. And once again, it's not their role is a monitoring one. So there are 3 bodies involved: the IQC, the Independent Qualification Commission. So basically, this body of specifically elected judges that assesses the asset backgrounds and proficiency of the judges. The commissioner, the public commissioner, that can appeal, that can say your decision wasn't right, you shouldn't dismiss, or you should have dismissed the judge. And then the appeal chamber, which is a specialized chamber of the Constitutional Court, so it has constitutional level. And there is then this international monitoring operation, the IMO, that monitors everything. And for instance, together with the public commissioner, it can say, well, in this case, you didn't do it correctly, or but it's not necessarily binding. So it's not as in the example that you were mentioning, whether they are against it or in favor of it. They show their opinion. It's a monitoring body for fairness, transparency, etc. But there was a big discussion as to the role that internationals should play
Okay.
and the issue of interference with internal politics, etc. Let me leave this aside. In terms of the impact of the reform on individual rights, it's too soon to say what the impact is, and actually the impact so far is not a positive one, but there are very positive signs going ahead.
Okay.
And the reason why it is not a positive one so far is because, as I mentioned earlier, because of the decreasing number of judges as a result of the vetting, the backlog of cases has increased. That has an impact on the length of judicial proceedings, which means that, of course, people cannot get a decision on their case in time. To counterbalance that, there are several mechanisms or novelties that have been introduced in order to increase both efficiency and quality of courts and judges. In terms of efficiency, for instance, and of quality as well, for the evaluation of judges, so judges are periodically evaluated. So what have you done so it's 3 years, every 3 years, up to 15 years of experience, and then after that, every 5 years. So every 3 years, show us what you have done. It's the High Judicial Council that does this for judges, High Prosecutorial Council that does this for prosecutors. What are the criteria? It's a mix of criteria. So it's the type of reasoning. It's whether you cite or not in Court of Human Rights cases. So jurisprudence. It's very specific. It's whether your reasoning makes sense. It's clear for the party that will read the decision. And these are part of the content of the case. But then there is another component, which is 25% of the whole package of points that you will get, which is about integrity and professionalism. And so attitude towards the parties, and you are respectful, do you use discriminatory language or not? And then there is another part, which is based all on statistics in order to increase efficiency, because the law foresees, or the council has determined certain time limits. For instance, for a case of this kind, for a divorce case, let's say, it shouldn't be more than X number of months.
There are some
So
parameters.
when a judge is being evaluated, all his cases are taken into account, and you see how many divorces he or she has decided upon, and whether the average is more than the indicated standard or not. So all these elements are supposed to, from one evaluation to the other, to increase the both efficiency but also the quality of the judgment. Why is this important? Because when a judge then applies for promotion, the result of the evaluation is relevant whether he's more. It's like a grade. You come with this average, and then you are competing against Sergei, who has a better average, and then you do not get the promotion.
You don't get the promotion.
So all these elements are supposed to trigger or incentivate the certain behavior of judges in terms of increased efficiency and quality. Another element of this is the obligation in the law, but as well as one of the elements of the evaluation of continuous training of judges. So you should not sit once you are a judge, you should continuously be trained, apart from the initial training, which is for the judges that enter the system. This is another element of increased quality. And this is expected maybe in the longer run to have an impact on the rights, on the effective protection, effective access to justice, and the protection of individual rights. And accompanied to the new judicial map that I mentioned earlier, whereby you concentrate, because currently in Albania there were some courts that were really overloaded with a lot of cases, pending cases, backlog, and then smaller courts were the same number of judges would be there, but they have very few cases. The new judicial map will concentrate some of those courts whereby the distribution of the caseload is more equal, and hopefully this will impact then on the reduction of the back.
Very interesting, and I mean it's interesting to see how both Ukraine and Albania have adapted to these reforms and how courts are dealing with some issues that actually stemmed from the very reforms, right? Because as you both mentioned, one of the effects of these judicial reforms was that of significantly reducing the number of judges. And on the one hand, of course, one can say that, well, these judges left because they weren't contributing towards the delivery of justice, in the sense that they were corrupt, they were impartial, they weren't independent, but at the same time, also lack of judges in a way can lead to a denial of justice in a way. So it's very interesting to see this tension permeating the effects of these reforms.
I just wanted to mention a difference compared to what you said. So in Albania, we haven't opened the door to non-judges apart from the High Court and the Constitutional Court, but not for other levels. So only professional judges, which puts a burden in the School of Magistrates that needs to produce
judges.
Exactly.
Okay. Very interesting.
If you permit me, we also have one difference with this evaluation. As I understood, you have evaluation every 3 years for acting judges.
This is normal, yeah.
I understand. We have evaluation of judges only in 2 cases. The first one is this evaluation of all judges in accordance to the Constitution after the Revolution of Dignity, the primary evaluation and evaluation for judges. And we did not finish it yet because the work of our High Qualification Commission of Judges was stopped in 2019. And it was almost 6,000 judges, all of them. And then if a judge would like to get any promotion, for example, from local district court to appeal court, it is possible only during the procedure of open competition. To all promotions from one court to from the local court to appeal court, open competition and procedure of qualification during this competition. If you would like to take part from in the competition from to promote from local court to the Supreme Court, only open competition. From appeal court to Supreme Court, only open competition. From local court, common civil or criminal specialization to administrative, open competition and evaluation during the competition, but not every 3 years.
But what are the criteria? No, what I meant, the evaluation is meant every 3 years, but the competition is open when the council thinks that there is a need in that court, it's open and it's public. But I was wondering, what are the criteria? Sorry for
no, not at all.
But
That's interesting.
It's really interesting. So what are the criteria for promotion? So for instance, you and I,
this is
apply.
A procedure from we can apply, yes, for only in the procedure. If I would like to, for example, only when there is a procedure of competition.
Okay, but my question is, what makes you win? So is it seniority? Is it
no.
What is it?
There is. It's necessary. There is a system with 1,000 scores.
So it's a scoring system.
Yes,
the same,
points. Yes, 3 criteria: professionalism, professional ethics, and integrity.
Exactly. And so these parameters are very.
Then the commission, yes, the first step is to pass exam, multiple choice test plus case study. And the second time, interview on the basis of research of your dossier, as I told.
Connections
professionals, disciplinary, opinion of public counsel for integrity, National Anti-Corruption Bureau, Secret Service of Ukraine,
Yeah,
national
exactly.
police,
Same.
journalists.
So there are points of convergence. It
Yeah,
seems.
yeah.
So,
The difference is that we don't have any exam at this point because that kind of test is taken every 3
Yeah.
years.
exactly.
So then you just apply with your paperwork and.
So it's a
But
more
the criteria,
bureaucratic
the
process.
criteria are very similar.
It's a more bureaucratic process that does not involve an exam. So it seems that, yes, so there's almost an additional step in Ukraine because there's also an exam
Mhm.
in addition to the evaluation of the panel. I mean, thank you very much for all these insights. And I would like now to move to the broader global context. So I would like to hear from you very brief reflections really on the following. So it seems to me that both the reforms in Ukraine and in Albania were introduced with the aspiration to enhance, one can say, the pedigree of judicial independence in your country, the standing at least of what also perhaps it was perceived internally as well as at international level when it comes to potential issues of corruption in the judiciary. So am I correct in thinking that the aspirations, the objectives of these reforms, both in Ukraine and in Albania, are very different to what has happened in Poland? Is this correct? Sergei.
I would like to mention that not only in Poland,
Very good
but
point.
also in Hungary, in Romania,
Of course.
and for last 2 weeks in Israel.
Yes.
Extremely noisy.
Yes.
Extremely noisy.
Yes.
By the way, why in Israel? They want to do two things. Their government wants to do two things, which we cancelled 8 years ago. The dependence of HR procedures from the government.
Of course.
And then to make a more weak Supreme Court.
Of course, yes. I mean,
it was what our President Yanukovych, who ran out from the country, made in 2010. He made zero Supreme Court.
Yes, yeah, now the
And
power of the
and
court.
then we return back. Then we return back. But it seems to me that in almost all cases of such events, as in Poland, as in Israel, as in Ukraine also before, it's one of the main points is corrupted top politicians.
Yes.
In Israel, there is information that one of the reasons is that the prime minister is under the sovereign investigation.
Of course, and then coincidentally there was
in this case, what is necessary to do to make influence on the court system? It's
so annulling judicial independence, so annulling separation of power and judicial independence. And I mean, Julinda, what about your perspective?
Support what you were saying. One of the aims of the reform was to avoid political influence in the appointing system of judges and prosecutors, and so this would be going back. But I feel that quite often the reason is that when the political system is surrounded, then the natural response is to attack the
So I think that this teaches us a very important lesson, that our vote as citizens is extremely important, in the sense that both of you made the point that, well, it depends on the I would say also the quality of the government and the politicians, and having the power to introduce these reforms. Well, it's crucial that we as citizens contribute towards electing governments that can respect the rule of law and promise also to comply with fundamental rights and separation of powers. And I have a final question of this very interesting afternoon, an interview with you both. So I think that we're witnessing a global trend of judicial reforms. So in the last years, I mentioned Poland, but Sergei, of course, rightly so, pointed out that, well, Ukraine, Albania, of course, have reforms, but this goes much further. We have examples in Hungary, examples in Israel, and I would like to add to these examples also two other jurisdictions actually that I have been studying for my own research projects. And these are the United Kingdom and China. And what we have witnessed in these jurisdictions is also a very interesting push towards judicial reforms. But in these two countries, what is the focus when it comes to judicial reforms is digitization. So digitization, in my view, is a very powerful phenomenon that could shape courts in very dramatic ways, both positively and negatively, in the sense that digitizations allow judicial procedures to be streamlined, to become more automated. And so in a way, this could also help the central governments perhaps to pressure courts to interfere with what courts do. So what I would like to ask you both is, why are governments across the world targeting courts? Why are we witnessing this attention to courts? What do you think, Sergei?
If we will find 2 months or 3 months to speak about it, it will be great. It will be great because even more, the ChatGPT appeared a few weeks ago, like hurricane. I discussed it with my students every day, and when I prepared for today's meeting, I made a small research of rule of law report of European Union from 2022, from last year. And I noticed that for 27 countries, members of European Union, they made 144 recommendations, only for judiciary, only for judiciary, but for court systems, and maybe 50% of all recommendations have been done to provide movement in electronic courts.
Very interesting.
It's not only countries from old democracies or from new democracies. I think that today #1 in Europe is Estonia. Austria, by the way, also moved very fast. I know that in United Kingdom there is but for family
yes.
Disputes, yes, and online disputes. But I am sure that until the end of this year, we will see huge changes taken into account in judiciaries, taking into account ChatGPT or some other tools of artificial intellect. Let's see. But I would like to mention the situation with COVID circumstances after COVID.
Of course.
And I don't know how it's in English when there are the two sides of
coin.
Yeah, two sides of coin. Yeah. So this is very useful in some cases, like in COVID. Oh, by the way, during the war in Ukraine, we continue our reforms. Our court system continued to work effectively, but the state gets more and more control on citizens,
of course,
including court cases.
Because of technology.
Yeah, because of technology, yeah. Let us see.
Let's see. But what about you, Julinda? Why are we reforming courts
So indeed,
much.
for digitalization, if this was the theme, has been a constant trend, as you mentioned earlier, in the last decades at least. And I think it's driven on the one hand by a need to reduce the cost of justice. It's a service offered by the state, so state needs to reduce the costs of justice, and on the other hand, by a drive to improve access to justice, including access to justice delivered in a timely manner. So the objective of ensuring effective access to justice is also included in the Sustainable Development Agenda of 2030, which recognizes and builds on the strong connection between peace, growth, development, and sound legal and judicial institutions. So all these elements are interconnected, and it is said that the rule of law and access to justice are an enabling factor to peace and growth. So there is this strong connection, so there is an incentive for states to invest on justice, reduce the cost, but also increase efficiency at the same time. So technology, as I just said, is an enabling factor of access to justice. But there is also the tech divide. So not everyone has access to technology. And therefore, this is an aspect that should also be considered and not ignored. Therefore, when developing access to justice standards and guidelines, international standard setting bodies such as the Council of Europe's Commission on the Efficiency of Justice, CEPEJ, otherwise known, set out on the one hand the need to guarantee fair trial standards whenever online proceedings are taking place. But on the other, also the need to offer online solutions as an alternative to in-person solutions rather than a substitute to that, just in order to limit the downsides of the technological gap. So not everyone can have access online or with the same level of efficiency.
Of course, because of the limits also in digital literacy, not everyone, of course, is familiar with technology, and I agree with you that we need to carefully observe these reforms because, as I mentioned, digitization can have a crucial impact on the shape of justice as we know it, and can enhance positive elements of justice systems, access, and also the ability of reducing costs potentially for applicants. But on the other hand, could be also an important attack also to the judicial independence that was at the core of today's interview. So I would like to thank you both for sharing your precious insights with us on your respective jurisdictions. I have personally learned a lot, and I'm sure also Ola has.
Definitely, and I just want to thank you as well, Dr.
Thank you.
And Dr. Julinda and Professor Sergii for coming on the program and for your time. And I just one final question from me from a perspective of the rule of law. Having given your involvement in this reform in your countries, for the countries that do not have the judicial, political appetite from the governments or the leaders of those governments to pursue a reform in their judicial system, what could you say in a nutshell is a learning from your involvement in your country that they could take away to make sure that that political appetite is there to reform a corrupt judicial system?
I have one proposal. Let us meet every 3 months to monitor changes.
Very good.
In Albania, Ukraine, and other countries of Europe, by the way, and other countries of the world. There is very interesting experience in Nigeria. There is very experience in Indonesia, very interesting experience in Indonesia. There are very experience in Latin America. Wow, Latin America, huge changes in
it's true.
the judiciary.
Of
Really.
course.
But let us discuss everything.
Let's meet and discuss
meet.
and let's share, of course, also the experiences. Yes.
Exactly.
Julinda.
Taking the Israel example that you mentioned, the reaction of professionals, lawyers, can be signaling changes that go into the direction of lack of independence or reduction of independence. Or judges themselves, they were very active in the response to the changes proposed by the government. So I would say civil society professionals can play a very active role, both advocacy and resistance in these regards, whenever there are signals. But this is not always possible. It's not a formula that can be applied everywhere. It depends.
Yeah, that's correct.
And sometimes those changes take place very slowly
Gradually.
and gradually, and when you notice it, it's too late.
Excellent. Thank you very much for your time. Really appreciate you coming.
Thanks to you
Thank
all.
you for your initiative.
Thanks to you all.
Thank you. Thank you so much.